view that as far as the exercise of that discretion by the president is concerned, there ought to have been published a CI or a statutory instrument before that is done. Why should anybody have issue with it? That is the position the members have taken. We may be wrong, we may be right. We all have views. And if you attend a meeting, the very fact that you have your personal views and various people have expressed various views, that does not mean that the meeting will not come to a certain decision. Once the meeting comes to a decision, it becomes the decision of the meeting. In that wise, you cannot be pushing your personal views any longer. So I don't think that it's fair to say that decisions have been imposed on us and going to the extent of mentioning the former Attorney General's name, the Deputy Attorney General's name. I was at the meeting. I didn't see my learned good friend Edugi there. He may have heard things, but I think that sometimes it is the best for you to have information firsthand before you comment. So for us, as far as the discretion of appointing the Chief Justice is concerned, the president ought to have done that under a published regulation as required by Article 296. Let us not forget that the Supreme Court is not bound by its decision. The fact that Joseph Fran's case said not in all cases that this must be done. Nobody is too sure whether the Supreme Court in the future can say that in the president exercising a discretion of this nature, i.e. suspending the Chief Justice, he shouldn't have done that under a published regulation. But once it's about the Constitution or law, that is a possibility. There must be clear guidelines as to how these things ought to be done. So that's a possibility to have the courts to interpret that for us.